All right, we are over time already, but I think we can take 2 questions. Can you stay for 2 more? And then we have to respect the fact that Harold Koh has a lot of things to do. Back there, yeah.
Thanks. Hi, Jess Brady from Wall Street Journal. I have a question for both Mr. Koh and Mr. Bellinger's views would be welcome as well. In 2008, the Bush administration authorized military commission trials under the prior Military Commission Act of 2006 for 6 alleged 9/11 conspirators, but charges were approved for only 5 of them. The 6th one, whose name was Katani, or detainee number 63, charges against him were rejected by the convening authority of military commissions appointed under the Bush administration, Susan Crawford. And the reason she gave was that the evidence against him, his inculpatory statements, were obtained through torture. And thus he remains at Guantanamo Bay, not part of the 5 who Attorney General Holder said would be tried in civilian court, and now perhaps is reconsidering that decision. My question is, under the Torture Convention and related domestic law, does the United States have any obligation to investigate the finding of torture by the convening authority of the military commissions or not? I mean, it seems to me that under the Torture Convention, when there is a reasonably sourced allegation of torture, a state party does have an obligation to investigate and possibly prosecute. Here, it's not an allegation by an outside group or by a detainee. It's a finding by a military official of the prior administration whose job is to determine whether charges can lawfully proceed. And while she approved them for Khalid Sheikh Mohammed and for other suspects, this one detainee, the charges were rejected. And then secondly, if he cannot be prosecuted because of this finding, what happens to this detainee? Thanks.
This is why it's great to be the present legal advisor.
Yeah, I'm not going to discuss a particular case, but I do want to talk in general terms about the issues that you raised. You're right that after the reform of the military commissions, there is a review. The interagency process, the detainee task force review process, did an exhaustive review of case by case. There's an extraordinarily detailed and careful process in which attorneys from my office participated. That led to a series of recommendations, and based on that, different kinds of prosecutorial calls were made, and you've referenced some of them. Questions of mistreatment were important in determining the weight of the evidence against somebody and how they ought to proceed. Now, we have in our system procedures by which allegations of misbehavior or improper action by government officials are investigated, and those procedures are followed with regard to particular cases. The new Military Commissions Act, as you said, doesn't permit the admissibility of certain kinds of evidence, and so you can draw your own conclusions for the reason why that particular case hasn't gone forward before a military commission. What will be the future policy about this? We have a complicated situation in that the policies were discontinued. And so we have inherited a group of detainees who we hope are in a different circumstance from individuals that might be encountered in the future. And as a result, the President is still making a series of decisions about the forward-looking policy. The so-called legacy issues are much more complicated because of these questions. But at the end of the day, they're being addressed on a very careful, individualized basis. I've studied many of these files myself. I've examined the facts of particular cases. I know the names and numbers of extraordinarily large number of persons whose cases are before the review process. And it's the kind of review that should have happened before. And I think it's being done in a careful, thoughtful, determined, and I think admirable way, recognizing mistakes that were made in the past, and then trying to figure out who should address the different issues as they arise in the future.